Hi, you're listening to the Lawyer Society legal podcast for lawyers, practicing advocates, law students, and judicial exam aspirants. Here is a space where we will be discussing case laws, interesting legal issues in very simple language because I'm a very young person and I'm not a legal expert as such. So we will just be having this space as a discussion platform where we can exchange thoughts, and also I get to share my thoughts on certain issues or provisions. In our first episode, I thought we will be discussing a simple topic from the Code of Criminal Procedure, which is whether a magistrate can in all cases treat a 156(3) application as a private complaint. Obviously, as most of you would already know, an informant is to approach a police officer and provide information, and that would fall under section 154 clause 1. And when the police officer does not record the information, he has the remedy of approaching the SP or the Commissioner of Police, as the case may be, and this would fall under section 154 clause 3. And in case the SP or the Commissioner also doesn't respond, now the informant has the option of approaching the magistrate. Now this would come under section 154 clause 3. This is all common knowledge as far as criminal side goes. So when the magistrate hears your application filed under 156 clause 3, he now has the option of either directing the police to conduct an investigation, or he can dismiss, or he has the option to treat the application filed under section 156 clause 3 as a private complaint filed under section 200 of the Cr.P.C. Now when he treats the application as a private complaint, he is taking cognizance of the matter under section 190. So thereafter the proceeding will go on as a private complaint case. There won't be any police investigation thereafter. But obviously there can be a police inquiry if the magistrate finds it necessary. But the scope of an inquiry ordered under section 202 is very limited compared to a police investigation carried from a direction given under 156 clause 3. So right now there is a very peculiar circumstance. There are certain scenarios where the magistrate cannot use his discretion to convert an application filed under 156(3) into a private complaint. Now suppose you are approaching the magistrate in a certain matter, and the magistrate thinks he's going to treat the same as a private complaint case. Can you protest? Can you argue that no, I want a police investigation here, I don't want you to take cognizance of the matter? The answer is yes. Now this is limited to certain circumstances. You can refer the case XYZ versus State of Madhya Pradesh. This is from the year 2022. The case number is Criminal Appeal number 1184 of 2022. It was decided on August 5th of 2022 by a division bench of the Honorable Supreme Court. In this particular judgment, the Honorable Supreme Court has laid down that in certain circumstances, like when a lot of documents are in the possession of the accused or any other persons, or there is evidence in the hands of third persons, or if the offense is related to sexual harassment, sexual abuse, so on and so forth, in such cases the magistrate cannot use his discretion to convert an application filed under section 156(3) into a private complaint filed under section 200. So in these scenarios, you can press and you can argue that you need a police investigation and you don't want the magistrate to take cognizance. So what if the magistrate insists that there is enough material and he goes on and takes cognizance of the matter? Now you can file a revision petition against the order taking cognizance, or you can file an appeal against such order, or you can file a 482 petition before the High Court concerned and argue that there is not enough material before the magistrate, and only a police investigation can recover necessary documents, inquire into witnesses, can catch hold of all the accused persons. You get the picture, right? So when the offense is so large, when the magnitude of the offense is so large that a magistrate cannot himself conduct a trial without a police report, then in all such cases the magistrate must treat the 156(3) application as an 156(3) application. He cannot take cognizance of the matter. Also, as per the Supreme Court's order, a sexual assault victim, a victim of sexual abuse or harassment, he or she cannot be subjected to more cruelty in the name of a private complaint case, where such victim has to be the prosecutor. He or she has to put forth sufficient material, which will not be possible in such a case, and a police inquiry cannot also do the needful if directed under section 202. So only a police investigation can do justice in such cases. Therefore, if you are involved in a very larger offense, say a 420, which involves multiple properties, multiple accused persons, or if you are involved in a sexual offense, then you can argue before the magistrate that he shouldn't be taking cognizance. Rather, he should be directing police investigation as you are praying for the same. So this is some new information regarding the limitations of the magistrate's discretion with regards to 156(3) and 200 of the Code of Criminal Procedure. If you like this episode, please do follow us on Spotify. Also, do consider subscribing to our monthly digital law magazine. In fact, this particular concept was covered in detail in the March edition of our magazine. If you are interested to purchase the March magazine or in subscribing to our digital law magazine, please do contact me on WhatsApp. My contact number is 98407-18196. You can also contact me through email. My email ID is lawyersocietyofficial@gmail.com. Thank you for listening. Stay tuned.